Thank you for joining us today for the ABA Civil Rights and Social Justice and Commission on Immigration Program Response Project addresses how our civil rights are being impacted by actions taken by the new administration. My name is Homero Lopez Jr., and I am the legal director at ISLA and previously served as an appellate immigration judge. And I'm thrilled to welcome you to this conversation. These videos are a unique opportunity to address what is happening in America today, clarify any misinformation or disinformation being spread, and how civil rights and social justice advocates can act to protect the rights of everyone. Today's topic, the recent Supreme Court decision in Mullin v. Doe regarding temporary protected status, is more critical than ever. As we confront a barrage of attacks from the current administration against immigrants, it's essential to examine how these issues intersect with the principles of justice and equity that guide the work of our section and the ABA more generally. We are honored to have with us Mary Giovagnoli, who is an immigration attorney, policy expert, and author who has worked for almost 30 years in both the federal government and nonprofit advocacy to improve the immigration system and strengthen democratic institutions. She most recently led the Office of the Ombuds for Unaccompanied Children within the Department of Health and Human Services. She is a former executive director of the Refugee Council USA and has held senior roles with Kids in Need of Defense and the American Immigration Council. We also have Kevin Gregg, who is a partner at Kurzban Sally and Pratt, based in San Diego, and the host of the Immigration Review podcast, where all of you should follow and which all of you should follow and get your case law updates regarding immigration. Their expertise and dedication to immigration law have made them leaders in their fields, and we are grateful for their willingness to share their insights with us. So let's get started. Kevin, can you give us a summary of Mullin v. Doe, what it means, what the Supreme Court said in this decision?
Well, as any good appellate advocate, I'm going to start Judge Lopez. I'm going to answer your question, but first, I'd like to address a couple issues. First of all, the fact that you're not currently on the Board of Immigration Appeals is something that everybody should know. It is a grave injustice, and it is an indicative of the all-out war that this administration has done procedurally and substantively against immigration. I also can't help but note that I'm happy to provide an easier name with Greg, although make sure you get the two G's at the end than Mary's. And I'm honored to be speaking today. I do have this podcast where for, 6.5 years, I've been reading every immigration decision and summarizing them. So it's all kind of floating in my head. And you mentioned in the intro, Omaro, that this is designed to dispel and to stop the spread of misinformation. I wish that what we were talking about today was misinformation, but unfortunately it's not. And Mullin v. Doe, which is also the Mullin v. Mayotte case, is a great example of really how horrifying for immigration and race-based claims our Supreme Court has become. So, temporary protected status is a temporary status that is given to countries per statute when certain events happen. But the statute presumes that it will be automatically extended. If a determination is not made every, say, 18 months, it's automatically extended. There are some countries that have had TPS for a long time, Somalia since the early 90s. That doesn't mean everybody from Somalia can come here, but it means that if you were here when it was designated, you can remain until there's a determination that it's safe for you to return. Um, the Trump administration came into office for the second time, as many listeners may know, and has terminated TPS for almost every single country. Ukraine has not been terminated yet, but almost every other country has, and all countries that are where the inhabitants are predominantly brown or black. The Mullin v. Doe case is for the Syria termination, and the Mullin v. Mayotte case is for Haiti. Our team has been fighting on the Haiti TPS issue since Trump won. The Kurzban law firm is part of the Mayotte team that ended up getting this loss in the Supreme Court. After winning, all TPS cases have won at the district court level. All of them that have been appealed have won at the circuit court level. But the Supreme Court has now reversed it. There's over 1 million human beings. Let me be clear, the practical effect before getting to the holding, almost over 1 million human beings can be detained and summarily removed. And the only thing preventing it might be an asylum claim for over 1 million individuals, many of whom have been here, some have been here for decades. The holding, though, and then I'll turn it over to you, Omero, for specific questions, and Mary, if you have anything to add, of course you do. The holding is twofold. We received a preliminary set aside in district court, which is an Administrative Procedures Act wonky thing because the Supreme Court took away injunctions in the birthright citizenship case last term, not this 2 terms ago. And that was based on two things. One, that the Trump administration violated the statute, and two, that they violated the Constitution. They terminated based on race, the race of the Haitians, the race of the TPS holders. And in the Haiti case, we got a set aside both because of a violation of the statute and because of a violation of race. Haiti being a predominantly black country. I don't know the statistic, but now this TPS statute says you're not allowed to sue and disagree with the president and the Department of Homeland Security's decision that it's safe to return people to a TPS designated country. Quite frankly, it's not safe to return people to Haiti. 85% of Port-au-Prince is controlled by gangs. The president was assassinated 3 or 4 years ago. Haiti is one of the worst places on earth. Everybody agrees. Our President Trump's own Department of State advises that if you're going to go to Haiti, you leave your DNA with a loved one before you leave, so when you're killed, if you're killed, you'll be able to be identified. The aviation, the FAA says it's not safe to fly into Port-au-Prince. Your plane might be shot down. Nevertheless, it was terminated, and we're not allowed to challenge that decision. We agree with that. I would not have written the statute, but Congress did write that statute. But there's old precedent, McNary from 92 or 91, and other decisions that say even if you can't uh, sue on what happened, you can sue about the process that was used to get there. The TPS statute says the DHS secretary must follow a certain process to terminate TPS, including consulting with the Department of State, to paraphrase. And in our case, it is undeniable, including by the Solicitor General, hasn't denied that Secretary Noam didn't consult with anybody. It was all pro forma. They violated the statute. Supreme Court held we don't care. The jurisdiction stripping provision that says you can't review any determination also includes how you got there. So what the Supreme Court said is the Secretary of Homeland Security can violate the law with TPS and you cannot sue. There's no other way to say that. And the Solicitor General was clear that that's what he was arguing for. On the equal protection challenge, this is what's getting a lot more traction, and it's equally scary. The majority says, well, all of those terrible things that were said about Haitians, that they all have AIDS, that they're poisoning the blood of Americans, that, why do we have more Haitians? Why not more Norwegians and Swedes? All of that stuff that Justice Kagan lists out in dissent, all of that to Justice Alito and the majority, simply political rhetoric. And so they don't think that there's an equal, that's not racism. To paraphrase the very smart professors on strict scrutiny, not to paraphrase, this is what they said. The majority essentially says that the xenophobia, whitewashes the racism, and so you don't have an equal protection claim. Again, pretty harsh words from me. I'm not sure how else to explain this. And so for equal protection and race-based challenges going forward, it's also a very scary decision, well beyond immigration. That's the holding. I hope that that wasn't too long, and I'm happy to talk about nuanced things.
Before we move on to some specific questions, Mary, do you have anything to add? You're muted, Mary.
I always love listening to Kevin's explanations of cases. He manages to tell you the story and give you so much good insight as well. I think I think one of the things that I found so both awful and frustrating about this case was just how much it continues to track this idea of taking issues out of context. It's like, the conditions in Haiti and in other countries in the world don't seem to matter at all. it's the attempt to read very narrowly, and Kevin can speak to this better than I think, but the way they sort of took the TPS statute and said, well, a determination isn't just the final outcome, it's the process you use to get there, to me is extremely worrisome from just a broad administrative law perspective, because it really says you can kind of read anything out of the statute. So Congress even has no way to ensure accountability, because the Supreme Court basically said, well, you can ignore
Yeah.
the rules of the game. And so what's so interesting to me about really almost all of the immigration issues in the court this term is how much of an impact they have on other areas of law. So
I believe in the Supreme Court and the rule of law. I'm a lawyer. We will die on that hill. That's what we do. But that said, it's impossible not to point out the hypocrisy and what is very clearly ends-oriented judging by the majority. Justice Alito and the majority have an expansive reading of the word determination,
mhm.
something that no one who hears that word would think is what a determination is. That is, that it includes the things that you do to get there, not just the ultimate determination. And they do that so they can lack jurisdiction. But in the next decision, we're going to hear from Mary, you're going to hear how they defined the term arrive in as
Exactly.
narrowly as possible so as to preclude asylum seeking. And when you put those two things together, and I'm not the first to say this about the Supreme Court this term, it is very hard not to be cynical.
And it's not like it was a different makeup of the majorities in those two cases and who was making those decisions
No,
that were interpreting it differently.
dare I
So
say
they
determinations?
So Mark Twain is attributed with the quote of, history doesn't repeat itself, but it oftentimes rhymes. And this, given particularly the race distinction or the race neutral justification that the Supreme Court gets into, reminds me of Korematsu and how that has been overturned. How do we look at this race neutral determination decision made by the Supreme Court? How do we, I guess, as lawyers, how do we prep ourselves to attack that in the future? And as advocates, how do we get around this? Or how do we fight back?
I'm not a constitutional law professor. I'm a lowly immigration guy. I do listen to constitutional podcasts. I think when you compare what's happening here with what was happening in the Voting Rights Act decisions this term, I think the Supreme Court's been quite clear that they're not interested in race-based claims. I think they're dead at the Supreme Court. That's not what I do. But that doesn't mean that the district courts will just roll over. That doesn't mean you don't keep bringing these challenges, especially where there's a record. But it seems to me that there's a majority on the Supreme Court that will find any reason to excuse a race-based reason and say, well, there was another possible reason, here xenophobia, or in the voting rights context, simply the political usual voting practices of majority black individuals, and that's enough to destroy your race-based claim. It's very scary. And before I be quiet on that, I'd be remiss not to note Justice Thomas's concurrence, which is not binding, but this is kind of what Justice Thomas does. He makes a crazy concurrence that in 5 to 10 years becomes actually a majority. He's been quite successful on it. Justice Thomas would say you can never even bring an equal protection claim against the federal government at all because the 14th Amendment focuses on states and the Fifth Amendment did not bring that. It's a
Yeah.
constitutional 101, but it is a wild holding and a very scary thing and indicative of how they keep moving the Overton window further, further, further so quickly to have civil rights advocates really on their back foot. It's been like that for a while, I'm sorry to say.
Yeah, and I think it also highlights in some ways the particularly cruel treatment of Haitians throughout immigration law. I wrote about this a long time ago on the Commission on Immigration's blog, but you just see this consistent unwillingness across really Republican and Democratic administrations to take seriously the level of persecution and danger in Haiti. And having worked in the federal government and attended meetings where this was, one of the conversations, it always has shocked me how often people are able to say, oh, well, conditions have changed, things are better, whatever, without really engaging And the Supreme Court is, I think, making an art now of this idea of not engaging with the facts. And as Kevin says, it's one of the things that comes up in the asylum case that I'll talk about, which is that context matters. And both this case and the asylum case are demonstrations of how much the Supreme Court has simply rejected that idea, I think.
That's unfortunate. Kevin, on a practical manner, as you said, leading into this, every district court that had heard this and every circuit court that had been appealed to had issued stays, had stopped TPS from being dissolved. What happens with those stays? What happens with TPS for folks that were protected?
There are sub lawsuits all over from just amazing advocates in the TPS space. But the other big case besides the Miotte case that we've been arguing is ACLU's lawsuit in the Ninth Circuit. Any set aside that was based on an APA violation to me appears dead. Now, the mandate I don't think is actually issued by the Supreme Court yet. It will within a few days, if not a week, at the time of this recording on July 22nd. So it's coming very soon. But every decision below that had relied on the APA is dead. I don't know if any other district court judges had actually granted the equal protection claim as well as they did in the Haiti case. So if they did, as in our case, we are still alive, but only just barely, and briefing is going to happen soon about what happens next. But the Supreme Court was pretty clear about equal protection too, but just not nail in the coffin yet. It also wasn't granted cert on that issue.
I think the curious thing too is that this is actually the kind of place where you could see if the administration changes hands and perspectives, going right back to the kinds of policy decisions that the Trump administration reversed, sort of by taking it out of sort of constitutional focus and really making it an executive branch decision. You can really see that it could ping pong back and forth and back and forth and back and forth. So it's sort of like, can you hold out until the next administration comes through and changes the policies again? And, fingers crossed that we'll be able to make that happen. Probably not supposed to say that in the ABA context, but anyway, but it matters, even more now who the president is, because they have such vast powers to affect so many lives.
Yeah. Thank you both, Kevin and Mary. Unfortunately, we're out of time, and these are quick segments to cover, but I appreciate you for giving us and providing us your expertise and information on what's happening and how this is impacting our immigrant communities, particularly those with TPS and the dark times that are ahead. But also at the same time, as you both said, there are opportunities for us to push back and fight back in the future. To everyone who joined us today, thank you for being a part of this important dialogue. The issues we've explored are complex and challenging, but in coming together in spaces like this, we're taking meaningful steps towards progress. Remember, the work does not stop here. It continues with the actions we take in our communities, our workplaces, and within the ABA. I encourage you to stay engaged with the Commission on Immigration. Follow us on social media to learn more about the work and how you can support it. You can also engage with the ABA Civil Rights and Social Justice section and become a member if you aren't one already. Visit our website, explore our upcoming events, and consider joining one of our committees to help shape the work we're doing. You can do so at ambar.org/CRSJ. Once again, thank you for watching. Keep up the fight. Thank you, Mary. Thank you, Kevin. And together we can make a difference. Thank you.
Thank you, and thank you to the ABA.
Thank you.